Hi everyone. I'm sorry I wasn't able to attend today. New South Wales Rail had other plans, so I hope this shall suffice. Thank you for having me speak today, and I hope everything's going well for everybody there. I shall start off today on the subject of best interests of the child. That is the mantra we repeat in the designation of best practice outcomes for children in the face of a dissolving or changing family unit in the arena of family law. According to the Family Law Act 1975, its meaning in Part 760B is stated that the best interests of the child are met by ensuring that children have the benefit of a meaningful relationship with both parents, where possible, protecting children from physical and psychological harm, exposure to abuse, neglect or family violence, ensuring that children receive adequate parenting to help them achieve their full potential, and ensuring that parents have obligations with respect to the care, welfare and development of their children. In addition to this, children have the right to enjoy their culture, including the right to enjoy that culture with other people who share that culture. Further to this, an additional stipulation within the Act at 60B3 states specifically where an Aboriginal child's or Torres Strait Island child's right to enjoy his or her culture be met by maintaining a connection with that culture and to have the support, opportunity and encouragement necessary to explore the full extent of that culture, consistent with the child's age and development level and the child's views, and to develop a positive appreciation of that culture. The purpose of this legislation is to set a legal industry standard. We aim for equality of outcome by application of rules that pertain to all within a nation by setting these guidelines and standards. We try to address those on the margins as minority within our society by including particular reference to specific needs. It is not a perfect system, but it is ever evolving. With the implementation of the voice, thereby further division, we ask, will outcomes be based on best interests of the child anymore? Or will they be based on best racial profiling, selected processes? The devil is in the detail. If we look at an example of what happened to baby Moana in New Zealand, we can take a dive into what Australia's future might look like with New Zealand's ever-increasing application of apartheid. A traumatised 3-year-old Maori girl with an untreated clubfoot and rotten teeth, Moana, after being removed for the third time from an abusive home, was given permanent placement with a white family where there was no Maori family available to take her, by Oranga Tamariki, previously known as the Ministry for Children, granted an annual budget of $1,198,615,000 according to 2019-2020 figures. After 3 stable years with the Smiths, Oranga Tamariki and the girl's tribe wanted her removed based on her cultural identity and moved 4 to 5 hours away with an unrelated Maori family. Reviews filed by a social worker said the Smiths were providing Moana a safe, nurturing and stable environment. What followed was a protracted legal battle that included Oranga Tamariki taking Moana from her daycare centre and placing her with another caregiver. A judge ruled that Oranga Tamariki had insufficient grounds to remove Moana and ordered that she be returned to the Smiths. A family court hearing is adjourned part heard after a few days when it became clear Oranga Tamariki had not provided vast amounts of information such as case notes, file notes and communications relating to Moana. Eventually, Family Court Judge Kalanikos ruled that Moana should remain in the care of the Smiths and is critical of Oranga Tamariki for its lack of adherence to the child's best interests. The 145-page decision includes stark criticism of Oranga Tamariki, its chief executive and numerous of its staff. The judge was particularly scathing of staff members' failure to appreciate the need for honesty and accuracy when compiling statutory reports and concluded that they appeared to place little importance in documents that were vital to a child's well-being. Judge Kalanikos said that the evidence is overwhelming and demonstrating that from the outset of their role, their judgment was influenced by a view that, regardless of all facts and principles, Maori children must be with Maori caregivers. He added that the ideal goal was to have children of a specific cultural group with caregivers from the same family or cultural group, but sadly that may sometimes not be available. The key flaw in such a belief-driven approach was that it distracted from the mandatory consideration of what was holistically best for the child. There was overwhelming evidence that the agency failed to provide the Smiths with any support to build their cultural capacity and it neglected their requests for more information on Moana's family and identity. An honourable agency would assess their own part in any failings rather than address them by a highly risky removal with all its incumbent trauma and distress to the caregivers and subject child, he said. Oranga Tamariki's inflexibility in its stance that Moana be removed from the Smiths showed the agency was either incapable of seeing the wood for the trees or that it was driven more by ideology than workable child-centred outcomes, or both. In either event, the ministry's final position was disheartening to see. Evidence showed there was a high risk Moana would suffer a disruption to her established attachments with the Smiths if she was removed from them. Moana suffered a lot in her formative years, the judge said, and the risk of undoing the gains obtained over 3 years is real and almost impossible to reliably predict at this stage. He chose a path that would see Moana benefit from the Smiths' loving stability, care and competence in parenting, while also able to benefit from the alternative selected family's strong links to identity and kinship. Moving on to March 2023, we sadly learn that Moana's family of 5 years say they can no longer deal with the ongoing legal battle for her care and have made the painful call to return her to Oranga Tamariki. The Smiths came to their decision stating that their reasons were the birth mother's persistent appeals for Moana to be placed in a Maori family even after multiple court rulings, associated ongoing stress, lack of support from Oranga Tamariki's office, harassment, the unviable nature of the situation for Moana, and the constant difficulty position Oranga Tamariki and Moana's birth family put them in, instead of coming together with them to support Moana in every way possible. We just couldn't go on. This was the hardest decision we have ever had to make. Family Court Judge Peter Kalanoka slammed Oranga Tamariki for putting ideology ahead of a child's best interests. Mrs. Smith said that despite the judge incorporating into his ruling a good amount of time for Moana to spend with her extended family and tribe throughout the year, of which they supported, it never eventuated. In this respect, we felt we were being set up to fail. How can we raise a child if people who barely know her and only would choose to see her for a few hours every few months are making decisions that affect her day-to-day routine? Mrs. Smith said that they were still grieving the loss of our daughter and we miss her terribly. We very much want Moana to be a part of our lives. She is and will always be a child of our heart. By running roughshod over best interests of the child, we perpetuate the very abuse the law has been designed to offer a safeguard against. With the funding in place for ongoing legal harassment and to undermine the enormous efforts of caring foster parents based solely on their racial profiling, speaks to the danger of segregated responses to best interests of the child. While the court system was able to play its part to the best of its ability in the application of the law, biased independent bodies with enormous funding are still able to strong-arm innocent individuals they discriminate against based on little more than segregated rhetoric, steeped in dishonesty, incompetence, selective reasoning, and an avoidance of the real day-to-day responsibility. There are lessons we can take from this here in Australia. What further segregations might we agree to fund by increased distinctions and labelling while hoping to safeguard our children? Will their best interests fall further down the food chain in the face of keeping apart those of different culture? Will the voice seek to separate citizenry status by cultural assignation? Will this formulate the new basis for good parenting? What of differences within culture? Is it possible we will make the measure of the right parent require a DNA test? Will different standards apply to different children according to those DNA results? What agencies will be set up to determine best practice for cultural truths or privileges? If privileges are to be awarded based on culture, will they be married with heightened responsibility? The Voice offers no explanation or safety assurances on these matters. Any increase in segregation will only lead to an increase in insecurity. We would be better to build on what we have so long worked upon in our systems, address systemic flaws within, rather than throw the baby out with the bathwater. A focus on division is devoid of shared meaning. It brings further confusion in practice and increased vulnerabilities into a delicate process where division itself is the theme already at the heart of family law practice. A greater division also brings with it greater fear. Will practitioners be guided by labels over law or law over labels? How will we operate in good faith in a system where we seek to mediate resolution for the protection of children going forward in already broken family units? We require standards we can apply and equally rely upon in order for us to feel secure. We must not seek to damage future generations with increased segregation. The Family Law Amendment Bill passed 11th of May 2023 this year has made further provision to extend meaning related to First Nations families, where kinship encompasses a wider range than currently reflected in the Act. Additional considerations in the right to enjoy Aboriginal or Torres Strait Island culture to maintain their connection with their family, community, culture, country and language, with increased awareness placed on the concept of extended family, where Victoria Legal Aid strongly encouraged government to engage in comprehensive consultation with Aboriginal community consultation organisations to make determinations. They also noted that the proposed amendments did not consider cultural diverse models of family or kinship. The definitions of member of the family and relative could be expanded further to recognise familial structures relevant to other culturally diverse communities. They encouraged government to consult with a broad range of community organisations and agencies to ensure these expanded definitions are appropriately worded. Where emphasis is placed upon the rights, particular emphasis is placed upon the rights of children, we expect it to apply to all of the nation's children. The United Nations Conventions on Rights of the Child, of which Australia is a signatory to, Part 1, Article 2.1 states, parties shall respect and ensure the rights to each child within their jurisdiction without discrimination of any kind, irrespective of the child's or his or her parents or legal guardians' race, colour, sex, language, religion, political or other opinion, national, ethnic or social origin, property, disability, birth or other status. 2 states, parties shall take all appropriate measures to ensure that the child is protected against all forms of discrimination or punishment on the basis of the status, activities, expressed opinions or beliefs of the child's parents, legal guardians or family members. With safeguards in place on multiple fronts, we do not require further weapons of segregation designed to confuse and deepen a divide. We've come a long way from a past where between the 1910s and 1970 over 7,000 children aged between 3 and 14 were transported to Australia as part of Britain's child migrant program. Promised a better life and loving families waiting to adopt, most were instead delivered into institutions where large numbers suffered abuse. These children came from varied parts of Europe and many had parents still alive in their place of origin. Coupled with the penal colony past that is often joked about, we might say that the Australia of today has been built on the disenfranchised. They are the homogenous Australian of today, with their loss of connectedness to state, title, knowledge of culture and history, separated from their familial past, many of uncertain biology. According to Shakespeare, it is a wise child who knows his own father. But there is no going back. For many, Australia is a place of new beginnings, immigrants desirous of a fair and level playing field. We must move forward as a nation with an emotional intelligence that values our children and family as the institution where all our journeys begin with shared understanding. Before I finish today, I would like to touch on the concept of labelling, what those assignations mean and what too many chefs in the kitchen might misuse in the name of identity politics. In an environment where division has begun to reign supreme with the mark of a class by labels, we still want to be viewed on our own terms as individuals within a number of alignments that provide us with a sense of belonging. A child's scope of being and becoming can be stifled by self-limiting beliefs associated with labelling. Where we seek to draw distinction that is not meritorious, we can condemn the young to a lifetime of labels and the connotations that go with them. They are dangerous when overreach, such as seen in New Zealand, renders them ripe for abuse during times where we have become afraid of our own shadow in a world where equity, diversity and inclusion are the pop phrases of the day. According to the French philosopher Jean-Paul Sartre, words are loaded pistols. They can point us towards truth, but they can also confine us. Words are both our tools and our traps. Labels serve as guideposts, but do not capture our lived experience or actual essence. They cannot capture the fluidity of culture, but serve as mere approximations that do not embody hopes, dreams, emotions, evolutions, or memories. We do not want the child of the future to be raised in covert apartheid, with fear, guilt, insufficiency, self-doubt and shame associated with identity politics, but with an education of collective responsibility befitting a civilised and sophisticated nation. Dr. Mark Rose states in his writings on the Great Silent Apartheid that racism by cotton wool as a product of the silent apartheid is married to the phenomenon of political correctness, and while it is often camouflaged by the misnomer of respect, it is highly detrimental in practice. The government of today has a duty towards the people of this country to provide disclosure about requirements, implications and restrictions that will arise from the proposed constitutional provision of the voice. That would require full community consultation from all Australians, due process, the publication of independent legal advice on the proposed provision, not multi-million-dollar propaganda, funded, coerced agreement. If nothing else, the last 3.5 years has pulled the curtain back on the nature of coercive control in the realm of domestic violence and its power imbalance on a nationwide scale. No one deserves to live in an environment where they do not feel safe, particularly our most vulnerable, our children. Thank you very much. I hope you enjoy the rest of the day, and thank you for having me.